Okay, welcome everyone. Thank you so much for making it here this evening. You could have been anywhere else, but we really appreciate you coming in today. Welcome to those who are online. Thank you for streaming in. We know that you couldn't come in live, but we hope you all have a good time learning about estate planning, um, how to avoid the three biggest mistakes in estate planning. And if you think estate planning is something else, you will know what it is. So my name is Attorney Jumoke Oladapo. I'm your trusted estate planning attorney. And we are from Ivy Law Office in Greenbelt. Here in Maryland, our office is opposite this building. We're in 6305 Ivy Lane, Suites 500. I'm the lead attorney there, and I'm the managing attorney at Ivy Law Office, and we'll do some more introduction in a few minutes. So the best way for you to learn today is to please put your phone on silent or turn it off so that you'll make the best for yourself and for your loved ones. I'd like to go through some disclaimers. First of all, I want to let you know that this is an educative session, okay? So it doesn't create an attorney-client relationship, but we'll be sharing information. I'll be giving examples. When it's time for questions and answers, please don't give personal information because it's online and it goes on YouTube and Facebook. But you can still ask a question, but don't make it too personal. This also will answer all the questions at the end of the presentation today to respect our time and to make sure we cover the material as fast as possible. Then we have a notebook or a notepad in your blue folder, please, and we have a pen, I believe. So jot down your questions. For those who are online, we'll want you to probably participate as much as you can. You can type into the chat. Hopefully, someone will be there looking at the chat and responding. If nobody responds to you, we'll get back to the chat and probably call you or answer your question in some way possible. If you registered for this event, we'll somehow get in touch with you. We want you to please make use of the content in your folder. In there, we have what I call a green worksheet. So this worksheet is going to be interactive today. Would like you to please complete your name, information, and while I'm going through the materials, I'll ask a question like in the second section that says, if you'd like to keep your family out of court or conflicts, please check this box. Then you check the first box. If I say something like, I need to name guardians for my children. Do you want to name guardians for your children? You check that box. On and on like that. That's going to be the interactive part. The third part is about next steps. So how can we serve you better? What other information do you want from us? You can check that box as well. And also put in your comments on how you enjoyed the workshop today. All right, we'll also want you to stay tuned to the end of the presentation. Please, please. When you do, we're going to give you what we call a golden ticket. The golden ticket, it's going to be valued total at $1,000. Okay? And we're going to talk a little more about it in a few seconds. So wait till the end to get a golden ticket and some other presents that we have for you just for coming in. Okay? I've spoken about the green worksheet. So at the end of today's meeting, one of the things I'll be asking you to do is please submit your green worksheet. All right? Please give it to one of our staff at the back. And when you do, you'll be given one of the gift certificates we have for you. This this gift certificate is valued at $750. And the $750 gift certificate will give you a complimentary one-to-one meeting with our office to speak about you, your family, your asset. Do you understand? It's going to be a 2 hour strategy session and it's valued at 750. All right. So for coming today and submitting your green worksheet, you get this. So, and it doesn't end at that. If you now make use of the 750 and register to attend what we call a family wealth planning session, you're going to get another gift certificate that gives you a $250 credit when you retain our services. Okay, so we want you to make the best use of this gift certificate today. And in addition, we're going to give you something called the digital asset checklist. All right. So 750 by submitting the green. When you now sign up for the complimentary meeting called the Family Wealth Planning Session, you get a 250 that you can use for the service and also a digital assets checklist. And you know what this is about? How many of you have a lot of users' names and passwords like I do? Mm-hmm. You know, those are part of our assets. Mm-hmm. All right. So we want you to be able to capture it and keep it and make it part of your planning. So that's what this is for. And it's proven to be very useful. It's in paper form, but that's a good start, you know, for people who don't really know what to do with those. All right. So thank you about that. So Ivy Law Office, we've been in operation for about 13 years, since 2010, 13 years plus, and we've been able to serve our community and we've been able to impact a lot of families and lives in many ways. And as a result of that, we've gotten some accolades, okay? These are just a few of them. But we've been named the Lawyer of Distinction. We do immigration law and estate planning. Okay, so some of these accolades are for immigration law, some are for estate planning. We've been named one of the top best attorneys when it comes to immigration law in Maryland. Also, for estate planning specifically, we're a member of a group called Personal Family Lawyer. We have the license to serve our clients in a special way, not just like the lawyer next door. So our estate planning clients really are special to us, and we serve them in a way that they see us as the trusted planning attorney. They see us as their go-to attorney as well. And we just provide for them so much value. And you hear about some of these values as we go on. We also have a lot of Google reviews, and not just the ones. We have a lot of 5 stars. Okay, 5 stars. We have probably about 80 or more 5-star reviews from live clients that have been served, clients that like what we do, clients that tell other people about us and bring other people to us. You know, of course, we have those little one, you know, of course, but those are very minute. Also, we're top 10 attorneys on Avo, and our law firm too is the top 10 law firm as well. Apart from myself being named as a top 10 attorney. Alrighty. So with us, we it's not just corporate, okay? When we have clients, we know our clients. So we want our clients to know us. This is my family, and what all this brings together, why we're doing this is because when we plan for the people we love most, okay? So if you have a family, you're probably here because of them. And a family could be your children, it could be your brother, your sister, your parent, whoever is connected to you daily. We also have a team, and this team serves with excellence and diligence. That's me. I'm the managing attorney. That's Attorney Will. That's Miss Moji. She's our legal research associate. That's Miss Princess over there. And we have Miss Terry as well. Where's she? So when you come, we work together as a team to give excellent services to all those who come our way. And we're looking forward to you being one of them. All right, to business. Thank you for coming. Do you know a lot about estate planning? Some people do, some people don't. But I want to make it like a 101, estate planning 101, for you to get a good understanding. When it comes to estate planning, think about things like a will, a power of attorney, a trust, a healthcare directive, and things like that. Some people think it's about real estate. I still had a call today from someone that was like, "Oh, I'm going to be soon, I'll soon buy a house, and I see that you do real estate." I'm like, yeah, I can refer you to a trusted real estate attorney, but we do estate planning. So I had to explain to the person. I get some comments like that from time to time. But I'm like, I know about it, because I used to be a settlement attorney before, a settlement agent, not an attorney, a settlement agent before starting the law practice. So come on, I'll tell you about it, and I'll refer you to those who know more. But if you don't know more about estate planning, it's about what some of the things I mentioned a few minutes ago. So do you currently have a plan? Yes or no? No? Yes?
Yes.
Yes.
Mm-hmm.
So thank you. We have a mixed audience. If you're online, you can tell us yes or no. Miss Princess, can you be on online as well for the chart? Thank you. Alrighty. So please type yes or no. But one of the other things I want to do before we go deeper is this. I want to know how you found out about us.
Eventbrite.
Eventbrite?
Mm-hmm.
Thank you.
Family friend.
Family friend?
Yep.
First name?
Can't remember on top of my head.
But thank you to the family friend. Thank you, Eventbrite. Oh my goodness. How about you?
Social media.
Social media like Facebook?
Yes.
Thank you. Thank you so much all for coming. Eventbrite, social media, family friend. Alrighty. So we've said some people say yes, they have a plan. Some people said no, they don't. It could be a mixed audience. I see a no as well, and I believe I don't know what
They got the
flyer in the mail. Probably okay. Thank you so much for attending as well for those who are online. So if the answer is no, why not?
Just haven't kind of time for it yet.
Time. Okay. So this is a few reasons why people have not. Some people are too busy, which goes into the time. Some people think they're too young because they think it's when you're in your 60s, 70s, and 80s that you start putting these things together. But no, once you are 18 and above, you have to have a plan. All right. Some people think in their head it's likely to be too expensive. The way we just assume, and just we won't ask, but we just feel it's expensive. But not having one may be more expensive than having one, and we're going to find out in a few minutes. All right. So this is some whys, and some of us relate to that. If you're online, why haven't you had a plan in place? please, you can type it in. All right, for those who have, why are you here today?
For me, I wanted to just be able to get connected with more attorneys here in the DMV. I moved here from Atlanta.
Come, we'll connect. All righty.
I just need to have a better understanding.
You just need to have a better understanding. All righty. So, some people want to have a better understanding of what they did and why, because a few people, when they have their plans, they probably had it done with traditional attorneys or online, where we've had is, there's I need a will, and they'll just give it to you. It says sign, sign, sign. Then you don't really understand what's the deed. You understand, but now you want to understand better, or even maybe what the deed was enough or not. Some people had their plans done on Rocket Lawyer, Susie Ullman. Where's the other place? I don't even know, but the Staples, but it may not work for them when it's needed, because a lot of lives are not boilerplate lives. Do you understand? When you want to have a plan, you want to have it specific to you, your family needs, not specific to the general rule, because a lot of times exceptions rule the world, not the general rule when it comes to law. All right, and for some people, their plans are outdated. Okay, and what is outdated? Some people have gotten these plans in place for 5 years, 10 years. The law might have changed. The law has changed, actually. Their assets could have changed. The beneficiaries could have changed. I've seen situations of people that had their plans done, and it's 15 years ago. And by the time they came to us, it's already outdated, because the people that had an agent are no more alive, or they've lost connections with them. Some of the beneficiaries probably passed away. And they're like, oh, no, this is not going to go anywhere anymore. So they need to make a change. But when you have plans in place, some of the things we recommend is having it reviewed at least every 3 years to make sure that it's still up to date. Okay? Why don't people plan? We find out that a lot of people shove it away because they think when the plan is going to hasten the occurrence of death. Is that a myth that any one of us believe it's true? But from the part of Africa I come from, that's a huge belief. People don't want to have a will done, not even a power of attorney, because they think it's going to happen soon thereafter. But no, that's a myth. It doesn't hasten its occurrence. In actual fact, it's just like when you have a car insurance. Doesn't mean you're going to have an accident the next day. No. Well, a lot of people insure their lives, they insure their cars, but they don't do the right things for everything they've worked out for. They don't even insure their lives. And they can insure a car, they can insure their own, but not other important things that pertains to them. This is some other myth. It's for the retired folks, or maybe you think you don't have enough. What do you think you need to have an estate plan in place? Is it for the wealthy? No. So it's not for the wealthy. And we'll find out why in a few minutes. Okay? Some people think because the will is the most popular document when it comes to estate planning. They think having a will resolve everything, but that's not correct as well. And we'll find out why it's not correct, because sometimes having a will alone may not be sufficient for you. Okay? And it may not resolve everything. So I've asked some few reasons. I don't know. Well, maybe the question I asked before is more related to how you found out about us. But this says, why are you here? Okay. So I want to have like, just tell me if you're married, if you have children or not.
Yeah.
Married with children, adults or minors?
A minor children.
Minor children. How about you?
I have children.
You have children but not married?
Not married yet.
Adults or minors?
Minor.
Minor. How about you, ma'am?
Married, but my children are adults.
Adult.
Mhm.
Okay. So one of the things I want you to write, why are you here? If you're here to have the total assurance and comfort of knowing that your family will be taken care of when you're no longer here on earth, then you're here for the right reason. Sorry. Please, AIREIRHERI. I have some problems with that. So it all sounds alike, and I think I pronounced them alike. So please
Yes. Air.
help me,
Well,
or just bear with me.
yes.
Okay. So another thing is this: a lot of us have assets, okay, or a lot of us have stuffs. Let me just call them stuffs, like your clothes, your shoes, your cars, your home, your jewelry, things like that. But you want to know and have the peace of mind that your assets go to the people you want them to go to, and not to the government, and not lost. Do you understand? If you want to know how to protect your assets for your loved ones, then you're here for the right reasons. Okay. Also, when it comes to estate planning, some people need to save on taxes. All right. We're taxed a lot in the United States of America. Income tax. What else? Transfer tax.
Oh, name it.
Recordation tax. What else? Sales tax. Whatever. It all just goes on. Then when it comes to estate planning, we have probate tax, estate tax, inheritance tax. It's just tax. Have it, they get it. Alrighty. But we cannot avoid it, but we can minimize it. All right. So when it comes to estate planning, it's the same. You want to know how to minimize taxes based on your hard-earned income. If you have that done, then you're here for the right reasons. Also, when it comes to estate planning, people forget that it's not just about after they're gone. It's also about when you're still alive in the event of incapacity. Okay? So you need to take care of yourself. If you want to be able to make choices and give directives on how you want to be taken care of in the event that you cannot make decisions by yourself anymore, then you need to put that in writing, and that's part of estate planning. So when it comes to having something like a power of attorney or healthcare directive, you need to go get that done. And we'll learn more about that. If you want to know more about that, then you're here for the right reasons. All right. So there's somewhere in Maryland and probably in various states called the Department of Unclaimed Properties. You know what happens to people that when they pass away, that the family may not know about all the things they have. Okay? Because some people are very secretive. All right. So let's say you have 5 bank accounts and your spouse knows about 3. All right. Well, there's one money market sitting somewhere else. Or maybe there's an investment account somewhere else. Let's say you have two retirement accounts. She knows about one, she doesn't know about the second one. She knows about three, things like that. When the person passed away, the family members will only try to marshal the assets, the no. So if you have five, they'll look for three because they know about the three. What's going to happen to the remaining two? It's going to go to the government. It's going to be lost to the government. And a lot of people don't know. In Maryland, we have over $700 million worth of unclaimed assets every year. Every year. And it's those accounts, those investment accounts, those bank accounts, those insurance policies, things like that. Even homes in the Department of Unclaimed Properties. So if you don't want your asset to be lost to the government, you need to, and you want to be more financially organized, then that's part of what estate planning should be. Because it helps you, in actual fact, it encourages you to pull together into writing everything you have so that the lawyer can have a consideration of what you have and what to do with them. So, if you don't want your assets to be lost to the government, then you're here for the right reasons. And that should be part of your estate planning. So we've gone through all those things earlier on. It's now time to start using our green worksheet. Okay?
I actually had a question for you about some property. Is that one good?
Yeah. So we're gonna have a session for questions at the end.
Sure.
So please, you can jot your question on your piece of paper. Then we'll take all questions at the end, so that will be fast. Finish fast. So start. Green worksheet. So what's estate planning? It's actually planning in advance to name the people you want to receive the things you want after you die, but it's not just limited to that. Okay? A good estate plan should cover much more. As I mentioned, both cover how you'll be taken care of in the event of incapacity and after you pass away. All right? So, because the word estate is like big, it's like a big word, we want to break it down. So, do you really have an estate? Okay? Believe it or not, everybody does. Everybody has one. So, if you have a car, raise up your hand. If you have furniture in your home, raise up your hand. If you have a home, raise up your hand. If you have a life insurance, please raise up your hand. Checking accounts, bank accounts, savings accounts. If you have investment accounts, raise. If you have rental properties, some people have timeshares. I don't. If you have clothes, fours, jewelry, Rolex wristwatch or any other wristwatch, personal possession, artwork, digital assets, usernames and passwords, cryptocurrencies. You see, the list goes on and on. If you have one or more of those, then you have an estate. So it's about everybody has, no matter how modest it is. I used to say, and I still want to say, even my late 21-year-old daughter had an estate when she passed away like 10 years ago. And I was like, what does she have? What does she have? But you know what? Because I didn't know better then, I went through probate to get some the insurance policies. That was what she had. That's what took us to probate. With a do you understand? So everybody does. So if you don't plan, you're just planning to complicate processes for your loved ones. So I want us to answer this question because we've identified that we all have estates. Who do you want to protect? Or if you don't have a who, what do you want to protect? Can you please jot that down? You name the people or do you name the what that you want to protect? Can you please let me jot that down for a few seconds? For me, what is most or who are the most people I want to protect? They're my family members, my children, my husband. Those are my who's. And of course, there are a lot of all the stuff that we've all gathered, and those are my what. It's sad that a lot of people don't protect their precious assets, and we all work hard. People go to work 9 to 5, and people that don't go to work, they look at the money. Do you understand? It's still some form of work because they don't want to lose the work. But then they don't have good plans or better plans with the money they're looking at or the money they're earning. A lot of people don't preserve their family's assets. So we want to do better if God has blessed us with some. So do we have the people and the things? Okay. So when it comes to planning, we dealt with some myths. We want you to have a mindset shift in a positive direction. And that is that there could be a better way to be served when it comes to creating a plan. You could have a better experience. You could have a new experience. And when it comes to the way we serve our clients, these are some of the experiences you have. You will be able to make informed and empowered decisions. Okay? You will be able to save your family thousands of dollars that could have been lost to the government or could have been lost to taxes because of improper planning or no plan. No assets will be lost upon death. You can protect your family's monies from outsiders. Creditors and predators, they're there. So you need to plan in such a way that you can protect what you have from them. Also, because our practice is relational, you have the right legal and financial choices and people to pass it by, the attorneys to pass it by. So our practice is one that is not like, oh, I need this, I give it to you, bye-bye, forget it. We check on our clients from time to time. We make sure that if there's a major change in their life, we'll look at their plan to see how does it affect what they've done with us. Do you understand? So, and if they have any questions, because we connect with them, some are regular, they're able to come back to us and ask questions. So you have financial guidance or lifetime guidance when it comes to estate planning. And for me, the one I really like is it keeps your family out of court and out of conflict. And I've made it my slogan. Our slogan for estate planning is that it helps to keep the families of our clients and their loved ones out of court and out of conflict in the event of incapacity or death through proper estate planning. So there is a better way to plan to keep your families out of conflict or out of court. Do you know that a lot of people have conflicts in their families because of money issues when loved ones are gone, upon the fact that they're grieving? It happens a lot of time. People fight a lot when it comes to other people's stuff. But we want to minimize it by putting things in writing and with proper directives. Okay? So ultimately we want your family's plan to work when it's needed. So for the people that have a plan, when was the last time you reviewed your existing plan?
2 years ago.
2 years ago. Great. Not is it recent? That's right.
No, it's probably been 6 months or so.
That's great. Do you know what? I have a beautiful audience with us today. Alrighty. As I said earlier on, some people don't review their plans, but you should review your plan at least every 3 years for the reasons I stated before. There was a woman that she had a plan. She did it like 10 or 15 years before she passed away. And in a will, she had a home, another rental property or investment property, and a bank account. She has 3 children. In her will, she specifically gave one house to one child, the second house to the second child, and the bank account to the third child. 15 years later, she passed away. She'd already sold the second home. She's already closed down the bank account. There was only one home left. And you know that home was a specific gift to a child.
Vestige.
What?
Yeah, it was gifted.
So, what's going to happen to the 2 children, the other 2 children? They'll fight.
Yeah.
And they were actually disinherited by their mother unknown to her. Why? Because she did not review a will that she had. When she sold those properties, she forgot that she gave specific gifts to her children. And at the end of the day, the person she gave the bank accounts to was supposed to be the personal representative. So he was very offended and did not do his job. So the person that got the home had to go to the probate court and get him sued. So that he either does his job or she removes him from being the personal representative because she needs the house. So review your existing plans, okay? But if you don't have a plan, what's the state's plan for you? Welcome, man. If you don't have a plan, don't think Sarah, whatever will be, will be. There's someone that has your interest at heart. Who are they? Who is the person? The state, the government. They know how to take care of those who don't want to take care of their things. And do you think it's a good plan that they will have for you? No. Maybe you're even interested in knowing what the state's plan will be. I got one for you. So, for those who pass away without a plan in place, their family or loved ones, one person will come up and step up and say, well, our dad passed away or a spouse passed away, we'll need to go through open an estate, okay? And that process in Maryland is the probate court or the register of wills or the orphans court. For this purpose, we'll call it probate court. All right. That's the state plan for those who pass away without a plan. But do you know, again, even if you pass away with a plan, but what you just have is a will, you still have to go through the probate court because the judge needs to sign off on it before title can pass to your loved ones. So some people say, I don't have things, I don't have a lot, but they have a car. Before the title of the car can pass to their loved ones, they have to go through the probate court because the person's signature, the person cannot sign that title again. Am I right? Because it passed away. Do you know how We'll take questions at the end. You can put your questions in the piece of paper that we have here. We'll take everything at the end. So do you understand what I'm saying? So it's better to have a plan, but to have the appropriate plan done. If you want to avoid probate, there's a way to go about it. Because a will leads you to probate court, no plan leads you to probate court as well. And in the event of incapacity, the person goes through the guardianship court. Why? You find a lot of people, well, the thing they're elderly, some people are elderly, some people are not. But I've seen a situation where I saw a man 1 month ago, and the next month I heard from the spouse that the person had strokes and autism. At that point, it's impossible for him to make decisions by himself. And this was not a whole old man, probably someone in his 50s. At that point, it was too late for him to be able to sign any documents over for his wife to take care of him. So they have to go through the probate court for the wife to be appointed as his guardian over his person, guardian over his property. So this is the state's plan for you. It's like a pipe of water. Okay? When a loved one goes through the court system, there's so many fees that will be paid as a result. So we have attorney's fees, executor's fees, appraisal fees for those who have homes, filing fees from the court, taxes, bonds will be taken, bonds premium. You know the hilarious one, creditors. And do you know what happens actually? There's usually a newspaper publication 2 times telling people, hey, this person passed away. If he owes you money, come before the court and make a claim. That pisses me off, but that's what the law allows. So at the end of the day, every other person will have taken part of your assets, and the remaining will now go to your beneficiaries. So there is one man that had an asset of about a piece of land worth about $1 million. By the time the land, all the stuff went through the probate court, the attorney's fee alone was almost $40,000. By the time the personal representative took his fees, and the personal representative may not end up being a family member. It could be a lawyer that the judge appoints, someone that you don't even know. So by the time the personal representative takes his fees and all those people take their fees, it's just going to be a slow drop of water coming out to the family. So, and this is how people lose their assets. You know, they'll say that their family became broke. And they'll be wondering, but this man has so much, or this woman had so much, but it's that she didn't properly plan. And a whole lot went into fees and costs and taxes because of lack of planning. So this is a state's plan for those with no plans or those with inadequate plans. So basically going through a probate court is like filing a lawsuit against yourself with your own money for the benefit of your creditors. How many of us like that? You may want to file a lawsuit against someone else, but filing a lawsuit against yourself, that's what it is. How many of us like this? No? Do you? No. So you don't want to put your hands in the life of your life in the hands of the government. or your life or your assets in the hands of the judge, or in the life of someone that the judge appoints as an executor. You want to put your own life in your own hands and plan for your loved ones and make decisions ahead on how you want things to be done, because you're owning your life, you're owning your assets. Okay? So, this is a summary of what Maryland probate is. I hope those online are having a good time. Alrighty. In Maryland, first of all, probate is public. And what does that mean? When people pass away, if they have a will, it's going to be put in the probate court system. Anyone can go there and look up someone's will. I don't even have to go to the court nowadays. I can check it online and know what's going on. And that's how some people, the people that do estate sales and realtors, some realtors, that's how they get their businesses. Some credit card companies or creditors, that's how they prey on minor children or teenagers who they know their father left some stuff. So you want to protect your family, you want to protect your assets. As much as possible, you want to keep your things private. Am I right?
Yeah.
Rather than public. Also, in Maryland, probate court system could take up to 12 to 24 months. And do you know what that means? Your family or loved ones are not going to have title to that home or to that car or to that asset until the judge says, now you're able to. And that's after every other person has taken their share. So, and that's why you see some people when the owner of the house pass away, they just continue to stay in the house. But does that mean they own the house?
No.
No. And they'll be paying the mortgage, but they're not the owners. Their landlord is dead, but they still have to pay the mortgage company. But they have a right to have title, but they can't. And do you know another thing that happens when people don't plan is that they can't even have those assets because now it's going to cost them a lot. The cost of probate is enormous. It's enormous. Okay? With all those fees I showed you, I know someone that the home itself is probably like a 200,000 or 250,000 home. At the end of the day, when the husband passed away and she wanted to go to the probate court, I was like, she needed an attorney to help her. I'm like, this process is going to cost you like $19,000. And she was like, where do you want me to get that from? It's going to cost you 2 years of your time. She was like, really? Do you understand? So people now get stuck, family members get stuck because of the cost. They have to wait on the judge. And of course, all the stuff now are public information. If you have better choices, will you choose this? No, not necessarily. There are some famous people that have their matters in probate court. And we think they could have known better. You understand?
They certainly should have.
They should have, but they did not do what they knew. Alrighty. So I want us to go to the green worksheets that I spoke about earlier on. And we've spoken about what probate looks like. Okay? So Is that something that you'd like your family to have to go through? If the answer is no, and you think and you wish that I want to keep my family out of court, that's in the second section. Please check the box. So this is our interactive sheet in the second part of it. When I say something that resonates with you, please check the box. So the first thing is, I want to keep my family out of court. Please check the box if that's what you'd like. All right, for those who have minor children, those who are under 18, beneficiaries will actually receive their assets, whatever you give to them or leave for them, outrightly and unprotected. And what does that mean? Let's say, for example, an everyday family has an asset of, let's say, $750. Am I right? If someone dies intestate, that means without a plan, and the person has a spouse. If they have adult children, the spouse will probably get like $40,000 and some other percentage, and the balance will go to the adult children. But if they have minor children, everything will go to those minor children with the mother. Okay? When the children turns 18, so let's say at this time the children are getting $350,000. Okay? Now the 18-year-old child will be handed over $350,000, let's say by the insurance company, because the person had life insurance. What's he going to do with that? Can you guess? It's not going to be
Not something smart.
not something smart. I'll probably spend it on, if he's a guy, he'll spend it on ladies and cars, fancy cars, and just parties. And if he's smart, maybe he'll buy a home or put it in an investment account. But at 18, he's probably not financially mature enough to think about that. So if you have minor children, you want to plan beyond what will take them to probate. So, for example, listing your minor children on your life insurance policies is welcoming them to go through probate if something happens to you. So, do you want them to have to go through the court process to get what belongs to them? When they now turn 18, for example, if you have a 7-year-old child, so long, that's like 10 years after, they'll get it. But then if someone is managing the money for them, it's probably almost spent. That's good if he's a lawyer that is managing the money for them, because the lawyer will be taking half fees. So you don't want your children to get things outrightly. And when it comes to being unprotected as well, it could be subjected to creditors. It could be subjected to lawsuits. It could be subjected to new spouses. You know, those people, they fall in love, they now got married. And because it was like an abrupt marriage, do you understand? It did not last long. Now they have to go through the court system and get divorced probably at, let's say, 21 years old. They got married for 3 years. This guy had an inheritance of $200,000, which he inherited from his father when his father passed away, and he got it at 18 years old. He got married at 19 years old. The marriage lasted for 3 years. That's 22. Am I right? And by the time he passed away, you know what happened? Not he passed away. By the time he got a divorce, he had to share that $200,000 with the wife. You know what he did? Why that happened? Because he didn't know the right thing to do. The money was commingled, so it became a marital fund because it was put in a joint account. And because it was commingled, the judge shared the money with the wife. Was that what the father intended? No. So that's part of where the unprotection comes from. But as she had the money put in a trust, then it's technically not a money. So the husband will not be able to, or the wife will not be able to touch it. But he wasn't wise. So when you're working with an attorney that knows about estate planning, those are some intricate details they look out for so that they help you protect what you have beyond when you're here. So if you go back to your worksheet, the second box says, I need to make sure my kids don't inherit money at 18 years old. If you have minor children and that is something that you would like to have done or that resonates with you, please check this second box. I need to make sure my kids don't inherit money at 18. Please check the second box. And the third box says, I want to make sure my children's inheritance is protected from lawsuits, creditors, and future divorce, no matter how old they are. If that resonates with you, please check the third box. Alrighty. So, we spoke about a lot of things that happen. How many of us know about the game of Monopoly? It has to do with money and homes and different things. Am I right? There's some, I grew up in Nigeria and we used to play that. And that's the first place I learned about Potomac, the one in Maryland. You know, and what we learned about it is that a lot of beautiful homes are there, and that's a place where rich people live. That is it true?
Yeah.
That's still true. So that's what we learned about Potomac. So coming to Maryland, I've driven to Potomac before, probably like 5 times, and building beautiful homes there. So, how well do you know your children and your siblings? When people fight over monopoly, that's fake money and fake assets. Am I right? How much more transferring that to the real world? When it comes to money, people can do anything, even lie to their lawyers. So, at the end, you can have different type of people, the loved ones that will remain together because their family or their parents or their brother or sister did the right thing. They'll bond together, they'll make decisions easily, or the person had already made its decision. All they needed to do was implement. Am I right? That's the first set of people that you see smiling over there. And you see the bickering siblings? It could be. It's real. Or maybe they end up in court because of the money, and the judge will make a decision about who gets what because the person did not make a decision about that already. Or maybe you want your home. Some different people have different ideas about what they want to do with the home they have. Am I right? Some people want to sell their homes and their children distribute the money. Am I right? But there's some people who don't want to sell their home. They want it to be like a rental property that will make money and to share the money. Something to create a legacy for them. The home remains in the family. Here they added, they just said it. They just spoke it. Maybe they have 5 kids and one of them heard that. But how about the remaining four? At the end of the day, one of the four was like, what do you mean that the home should stay in the home? The home should stay right here in the family. Please, this is $1 million sitting here. Give me my share. I need it. And now they want to cut the house into 5 pieces. You need to make wise decisions, but also write them down. Write what you want down so that it won't cause conflict in your family. Or the entitled teenager, you know, and she won't go to school because she has some money or she thinks the dad has some money. I watched the video the other day, and this guy is, the father left a lot of things for him, cars, beautiful cars, they have a home. And the mom gives him allowances from the father's estate, Probably, let's say he earns like every month, let's say it gets like $3,000, like an allowance. So it wasn't responsible. Go party, come back. It wasn't working. And one day the mom accosted him. I was like, "You need to be responsible with your life." Your father was responsible, and he was like, "Why should I have to go to work? My father had left a lot of things for me. Number one, and even if I go to work, they're not going to give me more than what you're already giving me." I was like, whoosh.
Yeah.
So that's this lady. All right. So you don't know who they really going to turn into when it comes to money matters. So you want to at least minimize minimize the fact that there may be conflict by planning things properly. All right. So for those who have young children, minor children, this is something important that I want to share with you. Your kids could be subject to risk even if you have a will. And you'll think, how so? For those who have a will, there's a part of the will that says nomination of guardians at the end. Okay? Where you have an opportunity to nominate who can take care of your minor children after you're gone. But one of the things that people don't realize is, let's assume they're not gone, dead gone, but they're incapacitated. For example, this lady, they have a baby, okay, and they left the baby with a nanny. Then one night, she and her husband went out wherever to dinner with the nanny. The nanny is like 16 years old. So they left, and unfortunately, she thought to herself, what if we had an accident? The dad and the mom, as in parents, they both went out. What if they both had an accident and passed away, or they had to be rushed to the hospital? What's going to happen to the 16 years old and the 3 months old baby? There is a loophole in that people don't take that into consideration. When you're still alive, you need also to have what I call short-term guardians or temporary guardians. These are people that are close by you. Because if there is an accident and the mom and dad are stuck in the hospital, you know what's going to happen? The police will take their ID, look at their own, then go to the home, and then they knock on the door. They'll find the 16 years old girl with a little baby, and I'll say, hey, we just want to tell you that so happened to these two people. Do you have authority to take care of this child? And she'll say no. Then they'll take the child away from her, and the child will end up with CPS. Is that what you really want to happen to your minor children? Because a lot of times people put their children in the hands of those who don't have legal authority to take care of them. But if you have legally appointed certain people, be it neighbors or brothers or sisters, to take care of your children if something happens to you, not dead, then they'll show the police will call those people that something has happened to this person, come and take this child. So we have this plan as part of our estate plan for those who have minor children, and the plan is called Kids Protection Plan. And I think every parent with a minor child should have that, because estate planning is not only planning for death, but also for life. So, if you need to name guardians for your children by having a kids protection plan, if you have a minor child, please check that box. Are we enjoying what we're learning? Yes, quiet.
Yes.
Oh, we're thinking a lot. Alrighty. So, also, part of planning for life is making decisions about how we'll be taken care of in the event of incapacity. All right. And this has to do with you having a healthcare directive or a power of attorney. A healthcare directive is needed because, let's say you're going for surgery. You know this the lady with the picture on the bottom is called Terry Shivel. Terry Shivel was in the news in the 90s. Okay. I think she went into a she became brain dead. And now she has loved ones. She has a husband and she has a parent. And both of them, I think she was on life support, you know, and now it's time for her to be taken off life support. The husband wanted her to be taken off life support, but the parents did not. Okay. So these are two people who loved Terry fighting over our life. What should be done? They'll fight. There was animosity between them, and they went to court. Do you know this court case did not end in the local court? There was an appeal and another appeal. Then it got to the Supreme Court of the state. It even got to this issue came into the then Governor Bush's attention. Why? Because Terry did not make that simple writing on who should make decisions, healthcare decisions for her. So it's important for us to do that. Do you want life support or you don't? Some people do, some people don't. Some people say yes for 1 year. Some people say yes for 3 months. Some people say yes for 2 days. You don't know. And you don't, nobody, people are not mind readers. Do you understand? Sometimes what her husband wants is different from what the wife wants. But if you don't put these things in writing, people will do what they wish, not what you wish for them. So it's important that you make these healthcare decisions. And when it comes to power of attorney, those have to do with your everyday life and finances. Do you understand? Who will go to the bank? Who will sign that check? I don't think people use checks nowadays, but who's going to transfer that money? Who's going to pay that bill? If the right people, the people you know, like, and trust, are not the ones you assign to do those ones, then you're inviting a judge to be assigned to assign someone. So they have to go through the guardianship court. Do you understand? And in Maryland, guardianship court is about 3 months. It takes 3 months to see the judge. Then when you now see the judge will appoint maybe the person that made the petition, But if there are more than two people wanting to be the guardian, there's going to be conflict. Do you understand? That is going to take longer time. I know of a situation where a dad and a stepchild wanted to be guardians over the mom slash wife. Do you understand? Both of them loved the mom slash wife, but you know what? They had some issues with each other. Husband and the child of the wife that was born out of wedlock. You understand what I'm saying? So she's a stepchild, but the stepfather doesn't really like her. I think there was some things she'd done in the past that he didn't like. So he now prohibited her from seeing the mom or taking care of the mom. And she was like, how will you not allow me to come in to see my mom when I know she needs care? Do you know what happened? She went to court to become our guardian. He went to court to become our guardian. And at the end of the day, there was this trial and fighting and bickering over a loved one. And the mom chosen with a power of attorney who should be our guardian or who should be our agent, then that will not be an issue. And people don't know when they need this thing. And powers of attorneys are powerful because even if you are not available, this is not about incapacity. I don't know whether you understand, but there's some people, for example, if you want to buy a house or you want to sell a house and you happen to be out of the country, you can choose a power of attorney agent to sign for you, to sign the loan documents for you. And it works. But if you don't have one, then you'll be stuck to come back and sign yourself. So it could be as simple as that, or as simple as choosing someone to go and pick your mail in the post office. If it's not their name, they're not going to give them. And it could be as complicated as Terry's situation. So we need to do something right, okay? So let's go back to our worksheet. I got you all today. Are you liking the information? All right. So look at the boxes again. The next box says, I need to have a power of attorney or healthcare directive. Or if you have one already, I need to review it. Please check that box. All right. Okay. How many of us have had about revocable leave trust? All righty. So we spoke about probate a lot. Am I right? But there's a way to avoid probate. And having a revocable living trust, and not just a revocable living trust, a fully funded revocable living trust is the best way to keep your families out of court and out of conflict and avoid your spouse or your children or loved ones having to go through the probate court. All right? And a lot of people will, what is this again? You know, but I'll call it a little sophisticated legal document, but it's not something beyond everybody's reach. All right? So a fully funded revocable living trust with disability provisions will keep your family out of court. It's a foolproof way to avoid court. And what does this entail? A lot of time people are doing DIY and they think, okay, or they use a lawyer that does general practice to get it done for them. But this may not answer the question. Because when you do it right, it's not just having the document alone that makes it work, because having the document alone will not make it work. All right? So if you say, oh, I want to have a trust done, and the lawyer or wherever you got it from, prepares the trust for you. That has not answered the question. But what does fully fund mean? Funding means you have to retitle your assets. Okay? Funding means your investment accounts needs to be retitled. It means your real property, your deed, needs to go from your name to the name of the trust. It means for your bank account, you have to sign a new signature card from your name to the name of the living trust, and so on and so forth. So when you come to us, or when you come to a good estate planning attorney that knows how to prepare a living trust, they're looking at all those details. How is your home titled? Is it in only your name? If the answer is yes, if you pass away, anything with just your name on it goes through probate. So if you want to avoid probate, you want to live in trust, you have to have this living trust prepared, number one. Then number two, retitle the deed from your personal name to the name of your trust. So that takes the house out of your name to the name of your trust. And now that's in the name of your trust, it avoids probate. Okay? So, and we look at all these assets in detail to ensure that nothing is left unaccounted for. And for those who have minor children, for example, and they have probably named their minor children as beneficiaries on something like a life insurance, they're welcoming their children to probate that way. But with an attorney who knows how to draft a living trust like us, we will say you have to change your beneficiaries, take your kids out of it, put your kids in a trust, put your trust as something like a contingent beneficiary, and your kids will have what you prepared for them in a trust rather than directly. We'll take questions on that. Can you put it down in writing? Then we'll take it all at the end. So it's important. This is very, very important. When you go to traditional alternative, I've had some people come to me. They said, "Yeah, they brought the trust documents they prepared before." But when I got the trust documents from them, do you know what? It wasn't executed. I said, "Did you pay for this?" They said, "Yes." So why didn't you sign it? The lawyer sent it to me to read. And of course, they were overwhelmed by the legal language in that document. And at the end of the day, the lawyer did not follow up or did not finish reading, so they did not sign, and now it's 3 years past. So I'm like, you wasted thousands of dollars to protect your asset, but you did not even sign the document. So to avoid this, we have a system in place. Honestly, when you come to us, we have a system in such a way that you won't only have the trust prepared, but we make sure you sign it. Do you understand? And we make sure you fund it so that it will work. Because without funding, a living trust will not work. So if you're spending money, you spend it wisely to protect your assets and loved ones from from conflict. Did I answer? Do you understand what fully funded means? Okay, and you understand what a living trust is. So a living trust is like a will, all right, but it's better than a will. And at the end of the day, a will takes you to probate. A living trust that is fully funded will not. All right. While you're alive, your things you still use them. They're in the name of your trust, but you still benefit from them. After you're gone, then it becomes irrevocable, and it will act like a will without the court's involvement. Alrighty. So we've said a lot of things today, but I want you to know that planning right and planning properly is the best for your family. So if you want to have the peace of mind that you've done the right thing for your loved ones, then you want to plan right. Some people need to have a will, some people need a trust. Okay? Some people, everybody should have a power of attorney. Everybody should have a healthcare directive. Everybody should have their assets organized so that it's not lost to the government. All right? We might have said a lot of bad stories, but there are people that do the right thing as well. And I want you to be that person. You know, when you watch drama on TV, why do we call it drama?
Because it's drama.
Because it's drama. It's full of hilarious things, sad things, nonsense things, chaos, some good things too. That's why it's called drama. But you don't want to create drama in your family when it comes to things about your life and your assets. Okay? So do the right thing and do it right for your loved ones. Plan for success. Alrighty. So let's do this. You can have all the things that we've spoken about in an easy way. You want to protect your assets in such a way that you will know that you've done the right thing. But let me tell you something. If I told you that, well, I can help you protect your assets, but you won't have access to it. It won't be yours. You won't be able to use it. It's going to become someone else. Will you really? You may not. Will you like that idea? Okay, so that's what irrevocable trust does. Do you understand? However, a revocable trust gives you flexibility that what you own will be yours while you're alive. Technically, you'll be able to be the beneficiary of your trust, even though you are the one that created the trust. You will be able to manage your trust. You will be able to be the beneficiary while you're alive. But if you have something that belongs to someone else while you're alive that you won't be able to really benefit from, it may not be what you're after. Okay? So for those who have like enormous amounts of assets and they want to do something called asset protection, we may give them some other recommendation. All right. But for a lot of everyday people, you may not necessarily need asset protection that strips you of your right over your assets. You want something that you'll be able to use while you're alive, and after you're gone, it gets distributed the way you want. All right. So today we are recommending a revocable living trust as a better way of having an estate plan in place instead of a will that takes you to probate. All right. So I want to ask a question in your mind could be, do I need a trust or do I need a will? All right. So look at this list. We spoke about what constitutes an estate at the beginning. Am I right?
Mm-hmm.
If you add up your car, your home, let's just take those two for those who have homes. If you add up all those together, is your asset over $50,000? Probably yes. Am I right? If you have a home, it's over.
I've been thinking about bank account, savings
Exactly.
account.
It could be, yeah. So if you have assets over $50,000, you may need a trust and not a will. Okay? And why? Let me tell you why. By the time people go through that pipeline, it's almost 5% of their asset that is taxed, that is gone away. All right? So we will make the assessment for you, but I'm telling you, So if you have assets over $50,000, think about having a trust, not a will. If you have a home or any form of real estate, think about having a trust. In fact, have a trust, not a will. Okay? Some people think about, oh, I own the house with my spouse. It's a joint property. Okay? That's cool. You know, some times ago I said anything in your name goes through probate. But if it's in a joint name, okay, it wouldn't go through probate. But it gives a limited protection. So if one person passes away, the title goes to the next person. All right.
Yeah.
But what if the two people pass away at the same time? Or almost the same time? Then the assets will go through probate. So a better level of protection is to have a trust that covers both situations. All right. If you have minor children, we spoke about that. It's better to have a trust, not just a will. If you have a blended family, have a trust, not a will. I don't know if I told you about, I didn't tell you, but I'll tell you now. Mr. James and Mrs. James, they have a home. All right? But let me call Jane and John. John and James. Jane. John and Jane James. JJJ. John and Jane James. They got married, they bought a home. They have 2 kids. All right? Along the line, Jane passed away. They have the home titled in both names. All right? So when Jane passed away, the title of the own became John's automatically because they had it as a married couple. All right? So John did not have to go through the probate, did not have to take the house to the probate court by law. So after a few years, John decided to remarry, and he remarried Joy. With the remarriage, at some point, John decided to put Joy on title. All right? So now it's the home that belongs to John and Joy, James. After several years, John passed away. Now, Joy decided to redo a will because it's not only our, the home now belongs to her. Am I right?
Mhm.
And she wrote that she's giving the home to our kids. You know, John and Jane had children. Am I right? At the end of the day, when Joy passed away, it went to her children.
Yes.
That's what blended family situations could cause. Another situation is people that caused John to disinherit his children unknowingly. Do you understand what I'm saying? So you want to think wide when you're creating plans, and it's better to have a trust to address issues like that. All right, where you'll be able to specifically provide for your children rather than get into that unplanned chaos. If you have problem children, you know, some people unfortunately have children that have addict issues, alcohol issues, drug issues, and things like that. If you have, or maybe they're special need children, you want to make additional plans for those so that your money doesn't get wasted, or so that the special need child will be able to benefit from what you leave to them without being taxed or without paying too much, being dropped off Medicaid. All right. So when you have such, think about having a trust, not a will. And also, if you're a business owner, how many of us are business owners here? If you're a business owner, you want to protect your business as well, in addition to your life. So if you have an LLC or if you have a corp, you want to make those part of your plan. All right? And you want to think about having a trust, not just a will. Is this helpful? All righty.
Definitely.
All right. So the topic of today says 3 mistakes people make when it comes to estate planning. I want to engage you. I want to hear your view. We've spoken about different things today. Can you identify 3 mistakes people make that we've spoken about tonight? And how do you avoid that? Any volunteer? Yes, ma'am.
One mistake is not having anything in place.
Yes, not having anything in place. Another one,
Not
No.
keeping it up. Go ahead.
Not planning correctly.
not planning correctly. Thank you. Another one, you wanted to say something?
Not keeping it updated.
Not keeping your plans updated. Exactly. Thank you. Thank you for your contribution. There are a lot more that we learned tonight. Am I right? Having just a will rather than a trust. Not planning correctly falls into that. All right. So, and how would you avoid this mistake that people make?
Come into your seminar.
Come into your seminar, my seminar, and you learn more. Are you able to know more? Yeah.
Hire a good estate planning attorney.
Hire a good estate planning attorney, not a general practice attorney. Okay? Because a general practice attorney does not know when the law will change. But an estate planning attorney is on top of it. Okay? All right. And what are your takeaways from today's seminar?
Revocable living trust.
Revocable living trust.
Mhm.
Any other person?
Get started now.
Get started now. Any other person? Everybody say revocable living trust.
Revocable living
Living trust. All right. Thank you so much because that's important for us to have, okay? Particularly if you have assets. Modest, no matter how modest it is. So we will help you get started to have your plans in place if you don't have any, or to review your plans if you have one, if you've not reviewed it in a while. And in a while means more than 3 years. Or if you think maybe the writing was not done, or if you think, or if you add your plan from Susie Oman, or from online, or from Rocket Lawyer, or from Legal Zoom, you want to review those plans, okay?
Or DIY.
Or DIY, thank you. Because all those are problems, could create a lot of problems. Yeah, a lot of problems. You have something, but it's not done right. So we want to get you started properly. And the way we start in our office is with you being financially organized. We invite you to have a family wealth planning session. All right. That's a 2-hour strategic meeting you have with us. And in the strategic meeting, we'll get to know about you, your family, and your asset. And how do we help you to get financially organized so that your assets won't have to go through unclaimed properties? We'll want you to complete our intake. Okay? When you complete the intake, you're able to gather a lot of information that will help us to help you. And you'll be able to make the best use of that 2 hours. Okay? So when you come for a family wealth planning session, ahead of that, then you will complete an intake. All right? You will think about everything you have, or as many things as possible. And let me tell you, a lot of people still leave things behind by the time they get to us. Do you understand? But we help them to remember before we complete everything. All right? So, also, having a family wealth planning session will help you to make informed decisions and empowered choices, like we've spoken about. Something like what's it called? Tereshagos, life support issues, having a healthcare directive, or having a power of attorney, or even choosing who will represent you. Do you understand? I've seen a situation before where someone chose, this person is married, but she did not choose her husband as an agent for something. I was like, I don't think my husband is going to be competent enough to handle that situation. So she chose a friend. So, but what's the default for a lot of people?
Spouse.
Spouse. But that for that person, it wasn't going to be a spouse.
They're too emotionally attached sometimes and can't make the right decision.
Exactly. But if she did not put that in writing, a spouse will take up that task. All right. So during the family planning session, you will know about our levels of planning. We have 3 different levels of planning, and you will choose the plan that is right for you and for your family. So we're not doing boilerplate. We're doing things specific to you. So you'll choose your level of planning. You will choose the fees. And all our fees are flat fees. And during the family planning session, you get to know the fees in advance or what's likely to be. All right. And suddenly you will know that your family will be expertly guided throughout your life or in the event of incapacity or death, because you will have done the right things for yourself and for your loved ones. All right. So I'm inviting you to please submit your green worksheet by the time we're done and get the $750 gift certificate towards a family wealth planning session. A family wealth planning session's value is $750. So when you sit down with me for that 2 hours, you could pay $750 for it. All right. And you will know that this is worthwhile. This is worth more than $750. However, because you came, we'll give this to you, and all you need to do is schedule a family wealth planning session. We have few dates available, few spots available as well. We're not a lot, so we can get one each. And schedule a family wealth planning session with $20. The $20 you're using that to secure your spot. You can pay it with a credit card. You can pay it with cash. Or debit card or Zelle. We'll secure your spot on our calendar, and also you will complete that intake sheet before coming and submit it. All right, because I don't want my time and your time to be wasted at the session. So 2 things: you complete your homework before the session and submit it, like 3 days before the session, submit it. Also secure your appointment with $20. Then you'll be able to use the certificate effectively. All right? And of course you come because that's going to be worth it. All righty. So you'll have a wonderful experience with us. I think our rates are flat fees. You are planning ahead to avoid problems rather than having a knee-jerk response to problems. Other lawyers may do hourly rates, but you may be unsure what the rate is going to be when you're spending 15 hours or more on a matter. Do you understand? Also, we are relationship based. So it's not just a transaction with our office. We create a relationship with our clients. We know their children because they tell us about them. Am I right? We know the names of their brothers and sisters. And if something happens to a client and we get a call from someone that has been named the agent, we're familiar. Am I right? And we're able to help that family navigate that situation. So those are some of the things that make us special, rather than just having a document and thinking you've done it. All righty. So are you thinking about having a plan done or updating your plan? Please do not procrastinate. All right? You don't want to leave your family at risk. And we want to help you take the action, so we're giving you a family well planning session opportunity. So it's time to use your golden ticket. Alrighty. Another gift that we'll give to you today, if you sign up for the so if you I explained before everybody came, if you submit your green worksheet, please complete it. Help us complete it. Let us know how we did today also. Also, the next step, you have an opportunity for other things. For example, if you want to schedule a family planning session, you check the box, you do so today. Also, if you want to have like a 15-minute call, a follow-up call, you can check that box and schedule that. If you want to have our e-newsletters, we send out e-newsletters like almost every week to our people in our clients' family. It's very educative. If you're interested in that, check that box. We'll get it to you. Also, we have a book. We're Clean Underwear. This is a legal estate planning book, and it's so interesting. If you want the electronic copy, we can send that to you as well. All right. So check that box, and you will get one. When you sign up for a family wealth planning session, everyone say, please say family wealth planning session. Family wealth planning session. That's the 2-hour strategic meeting. When you sign up for that and you come and you decide to engage our services, you can use the $250 gift certificate towards the plan you choose, if it's a trust plan or a wealth plan. Okay. This certificate has a date line on it, so you want to schedule and probably make use of it before the expiration date. So we're going to give this to you when you sign up, when you pay your $20 to secure your spot. We're also going to give you a digital asset checklist. So please make use of these opportunities. Take the next step for the benefit of yourself and your loved ones and your peace of mind and protecting your assets and loved ones from court and conflict and government. All righty. So now I think it's going to be question time. We'll want you to go to the back of the room and get this done. Or my staff will walk around while we're taking questions in the interest of time to get your green worksheet if you're interested and to give you the certificate. This is our information. For those who are online, thank you for attending. We'll want you to please send a call 301-276-0887, or send an email to csd@ivylawoffice.com and let us know if you would like to have a family well planning session or a callback appointment. Thank you so much for your engagement. If you have any questions, put it in the chat so that we can attend to those questions as well. All right. Yes.
I just need clarification. So at the family wealth planning session, that's $750, $20 today if you get your appointment. So now what are you doing? You said 2 hours. So what are you doing during the 2 hours?
So the family well planning session is an intensive educational session. Okay. We'll take a look. Before you come, you complete an intake.
Right.
That will tell us a lot about you and your asset. All the information you provide will be confidential. And I'll be able to, before you come, look through everything, study it, and be able to tell you what's going to happen to you, your family, your assets, in the event of incapacity or death, and make good recommendation that is specific to you and your needs. Do you understand? So I'm looking at everything one by one and making recommendation, because my needs is different from yours. It's different from hers. And I'm creating specific plans or I'll have an opportunity to create specific plans for each individual. If you're coming in as a couple, if you're married, please come in with your spouse because both of you are decision makers when it comes to things like that. And both of you will be able to learn and both of you will be able to ask questions. So that's what the 2 hours is about. It's
And
intensive.
so after that, how do you, no, so if you want to get a trust, then that's another step. I mean, actually,
So
you want to write your trust out.
during that meeting,
Mhm,
you'll have an opportunity to choose a plan.
mhm,
Do you understand? So if you want to get a trust, there's a trust plan.
mhm.
All right. And then you have an opportunity to engage your services during that meeting. If you want to engage your services. Yeah. Thank you for asking. Yes, ma'am.
When you fund your trust, changing say real estate and putting it in the trust name, do you lose your benefits that you have, like i.e. homestead discount?
No, you don't, because it's your primary residence that the homestead is on.
Okay. Even if you retitle.
Yes, even if you retitle it, you're still the trustees.
Okay.
Yes. Thank you for asking. You wrote down some questions, am I right? Can you ask them now?
Sure. One of the questions I had, I've seen people in estate planning, and I think you even had kind of mentioned it about like expensive watches, for example, or even jewelry. How do we get taxed on that? Because I don't understand why wealthy people actually care about buying like a $50,000 watch for, asset protection purposes. So can you help me understand?
Okay. Everything you own, including your personal possession, is part of your estate. Okay. And the way people save money into having homes, your home acquires equity. The same way you can have a expensive wristwatch because you want to save some money because it's going to acquire value. The same way jewelry, people buy jewelry, for some money and save their money in there and then probably sell the jewelry later. But your personal possessions are part of your estate that the government takes into account when it comes to probate. Do you understand? So when you have a trust, those personal properties too will have to be put in your trust. And there is a legal document that is prepared by us that assigns your personal property into the trust. Did I answer your question?
Yeah, you did. Thank you.
Yes. You had one?
No, I was on something like that.
Something like
Yeah.
that. How about you, ma'am? You had a question?
I did. So my question revolved around the around the trust. So of course I understand that when you own a home, it's best to have your spouse or whomever your heir is that you want that home to go to or transfer to upon your death. And you need to have that person's name on your deed instead of a will in order to make that happen and avoid probate. However, when you're speaking about a trust, so is the best step still to put that person's name on your deed, or do you take your home and put the home in the trust and then the trust transfer the home to your heir? I'm just trying to understand the best way of doing that.
The best way is the second way that you mentioned.
Okay.
So if you put let's say you have 2 children,
So this just use my husband.
you
So,
have a husband and you have a home and both of you own title.
mhm,
Am I right? When one passes away, it goes to the other automatically.
mhm.
But if the 2 pass away at the same time, it goes to
Probate.
probate.
Right.
if you want to avoid probate,
Mhm.
it's better to have it in a trust instead of just leaving it in both names.
Okay.
Do you understand? If you have your home in a trust, both of you will be co-trustees of the home.
Okay.
Do you understand?
Mhm.
If something happens to either of you or both of you, you've already made decisions about what you want to do, who it should go to, or how it should be handled.
Mhm.
So the trust provisions will manage that. Do you understand?
I do.
All right. Did I answer your question?
You did.
So it's better for your home to be in a trust
Mhm.
than in just both names.
Right.
What about if it's a vehicle?
So what I found out is that a vehicle actually can take someone to probate. Why? Because you cannot transfer title to the car without going through the judge. Probate. So I advise my clients to put their cars into a trust, to change the title to the name of the trust now that they're alive, so that they don't have to go through probate at all.
Okay, but when you say put it in the name of a trust, what do you mean? You just make whatever name you want to put it in?
You can, yeah, you can
But
make
you have
whatever
to do
name.
paperwork.
You have to do paperwork.
Yes.
You have to go to MVA,
Oh.
with the title and transfer the title to the name of what. So let's say
What if they
the
have a
trust
lien
is
on it?
Jumi Living Trust or Jumoke's Living Trust. So if I have my vehicle right now as Jumoke Oladapo, I go to MVA with the title and some other documents that I prepare, my lawyer prepares, and put my car into the name. So the owner will be Jumoke Oladapo Living Trust rather than Jumoke Oladapo. So that way, if something happens to me, my car doesn't have to go through the probate
That's what I
system.
do.
What if you're still making payments on it?
It doesn't matter. It can still work out. You just have to pass it through the lenders.
lender.
Yeah, the lenders approve that you have a trust, and it still gets done.
But I can find that information out through MBA. I mean, because that's what I have a vehicle, and it's only in my name, not my husband's name. But I wanted to put my husband in case something happened to me,
Mhm.
so he doesn't have to go and pay to put his name on the account.
Yeah, that's one way. That's okay, but just provides one layer of protection. It provides a protection if something happens to you, it goes to your husband. If something, a lot of people go around with their spouses all the time, or almost all the time, and now could have an accident together. If something happens to both of you, then the kids, if you have adult kids, will have to go through probate because of the car. So that's why a trust is a better option when it comes to titling, if your interest is in avoiding probate. All right. That's a beautiful question. All right. For those who are online, do they have any questions?
Yes, there's a few. One question I see is, can you have a will inside the trust, something that spells out if you want to be buried or cremated?
If you want to be buried or cremated.
Okay. So there is a type of trust called testamentary trust. Okay. It's having a trust in a will. All right. So there's a possibility of that, but sometimes it doesn't make sense to me because you'll have to go through the probate first before talking about the trust.
She was saying the will inside the trust. Right? Is that what you said?
Will in a trust. There's no will in a trust. But there's something called a pour over will. Okay? So we create pour over wills for our clients, but I call it a backup will. So you have a trust, then you have a pour over will as a backup. And you know why we do that? Because some people forget to put certain assets into their trust. Or they now realize that I've seen a situation before that after the person passed away, she had a trust, but there was this life insurance policy that she had a long time ago, and no beneficiary was on it. So, oh, like, oh, what? But you did a trust, you didn't mention. I was telling the child, she didn't mention this policy, but this policy showed up after she passed away. So we had to go through probate because of that policy that had no beneficiary on it. And when we went to court, what the court will ask you for is a will, not a trust. Because trust is a private document. So the court asked us for the will, and we had to give the pour over will because of this asset that was not accounted for in the trust, or that was not properly designated to a beneficiary. I hope I answered that question. So I have a pour over will in addition to your trust. The second thing the person spoke about was cremation.
Right, so they wanted to know if the will inside the trust could say that if you want to be buried or cremated.
Okay. There's another legal document. People call it a living will. Okay. In our office, it's titled Final Disposition and Memorial Instructions. So this legal document is what we use so that you specify whether you want to be buried or cremated. And if you have any other special wishes or special instructions, you state it there. And you'll also be able to state who your agents for the purpose of final disposition there. All right. So it's a separate legal document for that, not a will.
Is it necessary
I believe so.
to say whether you want to be cremated or?
Oh, it's better. It's better you say it so that people are not confused.
What if you, like in my case, my husband wants to be cremated, I don't. But I've let his family know. We brought it up around his family so that they know that if something happened, he does want to be cremated. So, they won't come back later and say they didn't know and try to, because, well, his mother's passed now, but, she didn't like the idea, but that's what he wants.
Okay.
And
But
so-
you know what? There could be another bossy leader in the family that says, no, we don't do cremation in our family. Do you understand? So it's better these things are in writing so that it's clear. And anyone who comes to object or oppose knows that, no, this is what this man wants. Do you understand? I know of someone, so we don't really do cremation in Africa. It's very rare. A lot of people are buried. But I know this guy that wanted to be cremated. Do you understand? He had exposure, in Britain and US and all that. I knew about cremation and I wanted to be cremated. But here it is, this African man who doesn't want to be buried. There was a lot of objection and fighting over that. But fortunately, he had it in writing in the living will, and nobody could object to that afterwards. So yes, it's better to have it in writing, notarized, stamped, everything, and that's part of estate planning. So thank you for bringing up that question. Any other one?
Yes, we have 2 more questions. The second question is, can the viewers online take advantage of this session discount?
Yes, you can take advantage of the session discount. Call or send your email right now to csd@ivylawoffice.com and say, hey, I attended the family law planning, I attended the seminar and I would like to schedule a family wealth planning session. And yes, you'll be able to make use of that. Also, you can call our office tomorrow, 301-276-0887, and we'll attend to you. Just let us know that you attended the seminar. All right. Any other one?
And the last question is, if you leave a car or even a house with a lien to a trust, can the person inheriting be responsible for the debt if the value is lower than the debt?
If the value of the vehicle
The vehicle or the house?
is lower. So, all those are issue cases that the lawyers will help you deal with. Usually, someone should not be, your estate should be responsible for your debt, not you. All right. So, if you have money to pay off the debt in your estate, it will be paid off. But if you don't have money, there is a hierarchy that payments will be applied to. Maybe the creditor will be able to get some, or maybe not. It depends on the value that is left. I hope that answers the question. Okay.
A question about the house. Uh, I'm following up on what she said. If the house is in your name and then you add someone onto your deed, then that means whatever you do on the decision, if you want to change anything, then that person on your deed also has to sign your paperwork. So I don't know if that's a good idea.
So from what I understand, there was a way that you could add a person onto your mortgage or to the deed of the house, but and I don't know the proper term for that, but like you're the person that makes the decision. Kind of the best way I can think of it is like with a bank account. You could have like your bank account, but you could have a person that's a signer, which means that signer can't do anything or make any changes to your bank account. The only thing they can do is benefit from your bank account if you pass. So it was a term, and I don't know the
I'll
term.
explain two things.
Okay.
I hope I'll be able to answer your question. So let's say that you are the owner of the house, and now you want to create a trust with your spouse, but it's only your name on the home. When you create the trust, you can still be the sole trustee of that home. Your husband may not need to be a trustee of the home. So what belongs to you is still yours, not necessarily both of you. Will that answer your question?
So he wouldn't have to, even if, let's say you.
So if the title is in your name
Right.
only, even if it's on the mortgage,
Say that again.
even if his name is on the mortgage, but the deed is in your name, when you create a trust, the trust, you can be the only trustee if that's what you want. Okay. So there are a lot of ways to walk around. There's so many things that a trust can help you accomplish. And when it comes to the bank account, you name, it's called POD, payable on death account. All right.
Transfer on death.
So
TOD,
it can
yes.
transfer on death to whoever you name as a beneficiary. That's a way that people avoid probate, but it's not the best way. Do you understand? But that's another way that we can recommend. All righty. Thank you for those rich questions that you asked, and thank you for participating today in the seminar. We really appreciate it that you came out and that you learned. Was it worth your time?
Yes.
Thank you. Thank you. Thank you so much. We appreciate it. So we'll encourage you to take the next step by scheduling a family wealth planning session. Ms. Tay and Ms. Princess are ready to assist you. Please submit your green worksheet and let's get started. I look forward to seeing as many people as possible in a family wealth planning session, and hopefully we'll be able to serve you long term as a client. Thank you. Have a blessed evening.
Thank you.
Thank you to those online too. We appreciate you. Have a good evening, and we'll be stopping now. We look forward to seeing you as well.
gonna leave it, but I'm not making that appointment, I just wanted to move this. Okay. That's all I need. I didn't need to sign that, you're not giving that to me. Oh, okay.
Is that the